Yep.
Good evening,
Good evening.
and we welcome to our 6 o'clock start of our ethics retreat. And Mrs. Sugars, can you please take the roll call?
You need to read the open record. Yeah. Yes.
Okay, this is our open regularly advertised meeting. Public notice of this meeting pursuant to the Open Public Meetings Act has been given by the board secretary on March 8th, 2023 in the following manner. Posted notice on the school bulletin board at the administration building, transmitted to the Courier Post, Philadelphia Inquirer, and the clerk of Cherry Hill Township. And I believe now we can go to roll call. Mrs. Sugars.
Mrs. Stratton,
Here.
Mrs. Fleischer, Mrs. Gallagher,
Here.
Mr. Greenbaum,
Here.
Mr. Mayor,
Here.
Dr. Rude,
Here.
Mrs. Tong, here, Mrs. Winters,
Here.
Ms. Stern.
Here. Okay. And now we will say the Pledge of Allegiance. If you could please all join me. Okay, and we will begin our meeting with our public comment. Public comment is an opportunity for members of the community to comment on matters relevant to the operations of Cherry Hill Public School District or within the authority of the Cherry Hill Board of Education. The board welcomes diverse opinions on relevant matters. Under established federal law governing reasonable restrictions on speech in public forums, statements which demean individual community members or groups or which are irrelevant to the operations of the school district or repetitious will not be permitted. Community members who would like to present information not relevant to the school district are always welcome to communicate directly to the district superintendent, board president, and all board members via email or other alternative means. And we will take a look and see if we have anybody in the room. It doesn't look like we have anybody in the room at the podium for public comment. And now we will look online to see if there are any hands raised. And there is a hand raised and the phone number starts with 856-489. Please go ahead. Please state your name.
Okay, hello.
Locality, please.
Hello, my name is Jeff Podowitz, and I live in Cherry Hill United. I'm reading from a transcript of some oral arguments, Perez versus Sturgis School District. This is a school district case, education law. Shai Duretsky, counsel for the school district. I think a plaintiff in this situation has several options. One is, as part of the settlement, to negotiate whatever compensation he thinks he is entitled for his non-IDEA claims. Another is to negotiate as part of the settlement a waiver from the school of the exhaustion requirements and then proceed to court. So there were options as part of that global settlement to get. Justice Kagan, but you know, Shea Durfosky, the full relief he was asking for. Justice Kagan, Sturgis was not, for all we know, offering any of those things. So what's he supposed to do? Shea Durfosky, negotiate. I mean, as in all settlements. Justice Kagan, better, negotiate better, just pound his fist on the table with your legal rule such that Sturgis doesn't have to offer any of those things because he can't. He has two choices. He can either reject a good settlement, which is enable him to receive educational services, or give up on the potential which this statute gives him of getting compensatory damages as well under ADA. That's the American with Disabilities Act. Note, this is not a large win. Look at what it took to get this, quote, win, a Supreme Court ruling. This ruling can help others. It will. But school districts will adjust. They always do. Until we see how other courts rule on other issues in this case, we don't know if there will be a win for Mr. Perez. That's very true. Or, in the end, the school districts will come out on top. And that has happened before. The question is, using this ruling, how will Mr. Perez's allies and advocates, and he does have both, be able to adjust, since we know that the adversaries, and he does have adversaries, as you can see, will always do. They'll always adjust. And they also have deeper pockets than he does. Thank you very much for listening.
Thank you. Okay, we will close public comment at this time. Now we will move along to our ethics retreat. And I'm going to turn this over to Mr. Jesse Adams, who is our field representative from New Jersey School Boards Association. It's really nice to see you. And thank you so much for making the time and coming to us. And I'm going to turn it over to you.
All right. Good evening, everyone. They've got some new members, obviously. We're into month 3 of the new board year. So to the new members, congratulations, I think, and welcome. For those who don't know who I am, my name's Jesse Adams. I'm the field service representative from New Jersey School Boards Association. I'm one of, right now, 8. We normally have 9 in the state, but we've also advertised, we've gotten approval to add 3. So, which is great because right now we average about 70 boards of education that we're responsible for, and we're going to be able to slice it up a little bit more. So that'll be a little bit of a breather. Field rep is responsible, but we call ourselves the pointy end of the spear. We're here to support you, provide whatever you need for professional development, answer questions, information. That's what we're here for. So if you need me, let me know. I can give you my contact information, but I'm available by phone, emails. That's what we do. Quick background: 22 years as a board member before I started doing this job, and I've been in this for just over 8 years now. So. Served on 2 boards simultaneously because the law allowed it back then, and board president on both boards, negotiations chair on both boards. So I've been in a lot of the situations and done a lot of the things that you all are doing. So I feel really good about when I talk to folks. I think I can at least give you a perspective of where a different board or different folks may do things. So tonight, we're doing one of your mandatory requirements. Every year, the full Board of Education is required to review the School Ethics Act, different than the Code of Ethics. And I think that's some boards in the state get confused. I say, well, we at reorg, we read the 10 tenets and we all acknowledge it and we've done it. And that's not quite it. It's also part of your CUSAC requirements. You're required as a board to review the School Ethics Act. The act itself, you should have a digital copy of it. It's an easy read. It's not one of those onerous statutes. You print it out, it's 9 pages. But within those 9 pages, one of the paragraphs are the 10 tenets, the Code of Ethics. So, and you are required to acknowledge that you know what the Code of Ethics is. That's a separate requirement, and you do that at reorg every year. But a lot of folks think because they do that, they've covered the entire 9 pages of the act, and that's not the case. So, but by Chapter 28 requirements, you're required to review this every year. And like I said, by CUSAC, you get graded on the objective evidence that shows that you did do this as a board. So your minutes for this meeting will cover any of your CUSAC requirements and get you your points. So we're going to spend some time talking about the School Ethics Act. Going to cover a lot of material. I think we've given ample time to do that. This is your time. So as I'm covering things, if you have questions, please throw them out. Let's talk and make sure that, because you're going to hear a lot of different things. And if something doesn't make sense or you got a question about what this means, please throw that out here because this is part of your professional development. So let's see. There we go. So first, you do have a, you do have a PDF version of the slides that I'm doing. So if you want to make your own notes, but you'll note that the first slide after the title page is a disclaimer. And our legal department is making us do this every year now. This is new. I can't give you legal advice. And that's what the disclaimer says. We provide information. I think every attorney that sits through these presentations, they'll tell you everything spot on. But if you were to get in trouble and you took this PowerPoint and you said you went to the SEC and said, well, I did what I did based on this PowerPoint, that's not going to hold water with the SEC. So if you do have, I'm going to give you a lot of good information. I can tell you it's all correct. But if you do need a legal opinion, that's what your board attorney is all about. Yes.
I'm sorry, Jesse, if you don't mind, or Mr. Adams, would you kindly say out the acronyms like School Ethics Commission, SEC?
Yep.
Because we have a lot of new people who may not know them.
Gotcha.
Thank
No
you.
problem. The School Ethics Commission, the acronym SEC. So understand that the School Ethics Commission, basically, we'll talk about them in a little bit, but the law itself and the information I'm going to give you, it's good information, spot on, but don't use it as your only basis for making a decision. If you need a legal opinion, please make sure you follow your board procedure to reach out to the attorney. And the reason I say that is that every district by law, you're required to outline who can contact the board attorney. And the reason for that, if you've ever dealt with attorneys, you give them a call, what do? There's this little thing sitting by the phone, right? And they hit it, it's a timer, and you're on the clock. So when you call the attorney, you're charging tax, you're executing taxpayer dollars, and you can't just do that willy-nilly. That's why every district is required to have a process. So we always tell folks, make sure if you need to contact your board attorney, you follow your board process. I can tell a typical process is superintendent, business administrator, and board president automatically have leeway to contact the board attorney. And if anyone else needs to, you get permission through the board president. That's what we see typically in board policies. But whatever your policy is, make sure you follow that before you actually start talking, so you don't obligate government taxpayer dollars, out of your budget without authorization. All right, so that's enough of the disclaimer. One other thing, Chapter 28 of the Title 18A statute, Chapter 28 regulation, similar to policies and regulations that you have in your district. Chapter 28 is the regulation on the School Ethics Act. That went through a revision, went through hearings last year, the whole 9 yards, as it's supposed to go through. And then we put together this year's presentation on ethics. It was the changes that were recommended were pending a vote by the state board. And that vote hadn't taken place by the time we started our new year. So we put in the changes that were coming, and we highlight them in our presentation. February 1, they took the vote. So these changes I'll talk about are actually in place right now. So I'll tell you what some of the new rules are that you need to be aware of. So bottom line, the act itself, it deals with accountability. School board members are accountable. And you might say, yeah, well, we're accountable to the people who voted us in and all that good stuff. And yeah, I guess you are, but you're really accountable to the children, because that's what your role is. I tell boards all the time, it's not about the adults, it's about the children. And so your accountability is to ensuring that you provide the best that you can provide for the students in the Cherry Hill School District. That's it in a nutshell. Now, accountability wise, if your public doesn't like what you're doing, they can at the ballot box, they can change people out. So there's that accountability piece. But the bottom line is you're accountable to ensuring that you do the best that you can for your students. Okay, the act itself came into being back in 1991. And, like I said, it's not a real large act, 9 pages, but the bottom line is you're the elected officials, and what you do, what you say, how you act, the things that you do should not in any way, shape, or form break the public's trust. That's why the act was put into place, because back in the 70s and 80s, it was a different world here as it related to boards of education, superintendents, business administrators, a lot of things that the public did not like that was going on back then. Nepotism, superintendent contracts are a good example. There were superintendent contracts in the state that had car allowances, cars, clothing allowances, things like that you get into corporate America. Well, there were superintendents getting that kind of stuff in the state of New Jersey. There were boards of education where everybody had family members working in the district. It was a way for people to get employed. And then there was a waste of taxpayer dollars that were taking place, and the newspapers were publicizing it, and the public there was an outrage back there in the 70s and 80s. And the legislatures finally said, we can do something about this. And they put the School Ethics Act in place. Now, I will tell you all, as school board members, you're the most monitored, most regulated, best trained elected officials in the state of New Jersey. And you get paid very well for that privilege, right? Yeah. So, but the bottom line is what you do should never break the public's trust. That's the act itself in a nutshell. But who's accountable to the act? We get this question a lot. Basically, all school officials, and school officials is defined as board members, administrators, superintendents, business administrators, and other administrative personnel based on their role. And what I mean by that is if they have the ability or involved in personnel decisions, or they're involved in financial decisions. For example, maybe the business administrator has put together a blanket agreement with Staples for office supplies. And there's a list of folks that she's provided to Staples on that contract, and they're authorized users. So a principal may be on that list, can call Staples for a delivery of paper if they needed it at the building. You're obligating taxpayer dollars. You've been approved to obligate taxpayer dollars. You now come under this act because it deals with conflicts of interest and those kind of things. So those kind of administrators are held accountable. New Jersey school boards, all the employees at New Jersey, we're under this act. So we're held accountable to this as well. Now, in the act, we'll talk about disclosure statements, conflicts of interest. Within the act, there are 2 provisions that only apply to board members. That's the Code of Ethics. I think it's paragraph G, the 10 tenets of the Code of Ethics, and the mandatory training requirements. Those 2 paragraphs only apply to board members, and we'll talk about those. The act put in place the disclosure statements that we have to do by April 30th every year, with the exception of newly elected or newly appointed folks. First time you're elected or appointed and you're sworn in, you've got 30 days from the date you get sworn in to get your your ethics and personal financial disclosure completed. Once you complete it within that 30 days, then you go on the normal cycle with all the veterans, which is April 30th. Every year we have to have submitted our personal financial statements each year. It also put into place mandatory training requirements. It set up the School Ethics Commission. The SEC was established through this act. And then the act itself focused on conflicts of interest. The Code of Ethics itself was not a part of the original act. It was pending. And what happened was the state board and the DOE reached out to School Boards Association, asked us to recommend a code of ethics. We reached out to the Superintendent Association and the Business Administrators Association, and we collaborated with them back in 91 and came up with a recommended 10 tenets that should embody the code of ethics. That was submitted to the state board, voted on, approved, and in 92, that paragraph was put into the Ethics Act, the School Ethics Act, and that's where those the code of ethics actually came from. There we go. Who enforces the act? We talked about them, right? The School Ethics Commission. It's a 9-member commission appointed by the governor. The governor appoints folks to a 3-year term. And you can see on the chart the makeup of the 9. By statute, those are the types of individuals that serve on the School Ethics Commission. 3-year term, maximum of 5 from any one political party. And the reason for that is boards of education are supposed to be apolitical. So they never want it to be dominated, by one political party. So that's in the statute, no more than 5 from any one political party. So that's the commission. They have a lot of power and authority over all of us. 2 of their major responsibilities are advisory opinions and ethics complaints. I tell boards all the time, the easiest way to remember it, advisory opinion, before a violation of the act, an ethics complaint, somebody believes that a school official has violated the act. So you got the before and the after. Let's talk about the advisory opinions. Jesse Adams, school board member. I'm going to take an action, but I'm not quite sure if the action I'm thinking about taking may cross the line and get me in trouble with the School Ethics Act. So I need an opinion. So I need to go get an opinion. Where do you go for your opinions? I said that earlier. Your board attorney, right? So that's the person you normally would go and get your legal opinion about, I'm trying to do something. I think it's okay. What do you think? And the attorney will give you the legal, opinion. You might not like that opinion. Hey, I can tell you, having been a board president for many years, there were times that attorney gave me an opinion and I didn't like the opinion, but ultimately we ended up having to do it because it was the right thing to do. But you may not agree with the opinion you got, right? Ethical question, you ask the question, you get an opinion, you're not quite sure. You can go get a second opinion. That's what an advisory opinion is for. You can send an advisory opinion request to the School Ethics Commission and they will respond back to you. It's a confidential communication between you and the School Ethics Commission. You send it to them. They have folks on staff who look through it. They'll look at past advisories, but then they'll staff it. And they meet monthly, and at one of their monthly meetings, they will review your request. They will make a decision, and you'll get a written response back. Now, like I said, that's confidential, but the law does provide that if 6 of the members, they take a vote, and 6 of the members believe that this advisory opinion request, if any school official ever did this, not just this one person would be in trouble, but any school official, then they can vote to make it a public advisory opinion. Now, I just said it was confidential. If you read public advisory opinions, you don't know who the board member was. You don't know what town they're from. You don't know what board they're from. You see the facts of the case and the decision of the SEC. When they make an advisory opinion public, it becomes just basically an addendum to the law. And so if this advisory opinion comes out and says, if anybody does X, Y, and Z, you would be in violation of the act. That means if you do that, you're going to be in trouble. So those things, when they hit the public advisory, there's a public advisory website on the DOE in the School Ethics Commission section. When those public advisory opinions, the day they hit, we're all accountable to it, whether we know it's there or not. All right. So it's important to understand, saying violating and saying, I never knew it was on the website. That's like taking the thing and saying, I made my actions based on this PowerPoint that Jesse gave me. That's not going to hold water, right? So, what we do, and I'll talk about it in the end. We New Jersey school boards, we do our best to make sure that you're aware of these advisory opinions when they come out, so that you know about them in advance. So, advisory opinion, that's what it's for, to get an opinion. Also, I'll just mention, if you get an advisory opinion back and it says don't do it, and you do it and you get caught, you might have a hard time with the School Ethics Commission when you're at a hearing and they said, didn't we tell you not to do that? Yeah. So ethics complaints, pretty simple. Anybody in the state of New Jersey who has the facts can file an ethics complaint against a school official. A lot of times board members believe that the only people that can file ethics complaints against are the people who voted them in their towns. Not true. If I know Warren, up in Bergen County, if I know of a board member in Bergen County at the top of the state who I believe violated the act and I had the facts, I could go online, file a complaint against that individual if I had the facts. So it's anybody can file an ethics complaint. So it's important to understand that there is a process that it goes through. When the complaint is presented to the School Ethics Commission, they in turn notify the person that the respondent, the person that is being complained about, that someone has filed a complaint against you. You have 20 days to basically tell us your side of the story. And then, so that process goes, and at the end of the 20 days, if you don't answer, doesn't stop the case from continuing on. So, but they give you 20 days to give your side of the equation. So it go, and if it does proceed through the process, it's going to go through, hearings, witnesses, the whole 9 yards in Trenton. I tell folks, if you get notified by the SEC that you have an ethics complaint against you, you are at the beginning of a legal process. You need to be aware of that, because whatever happens, the appeal rights are to the New Jersey Supreme Court Appellate Court Division. So that's where appeals go. So the minute you start that process, you're in a legal process. So you want to make sure you're dotting your I's, crossing your T's, and you feel good about whatever your side of this case is, because if you want to appeal or the other side wants to appeal, it's going into the Appellate Court Division. So the SEC annually, they average about 85 ethics complaints a year, and public advisory opinions, advisory opinion requests, they average about 35. Each year we identify the cases that actually made it through. Last year, out of the 85 or so cases, ethics complaints, 8 were found to have been in violation of the act. So you see, it's not a large percentage, but there were 8 last year. Public advisory opinions, 35 or so requested, 8 also last year. 8 public advisories were released last year. So there were new situations that were added to the list of things that we have to worry about. So that's, but that's the annual average activity that the SEC has been seeing. One of the things when a case is filed, the SEC, when they do their initial review, they take it from the perspective of the person making the complaint. And they say, okay, if the person who's making the complaint and whatever paragraph, whatever they're citing as a violation of, they look at the facts and they say, if these facts are true, would they actually be a violation of the act and the paragraph that this person is claiming that the person violated? If they say, yeah, it could be true, then the case is going to move forward. If they say, no matter what, based on these facts, even if they were 100% true, it wouldn't be a violation. They're not going to waste the time taking it through. They're going to dismiss it. So they always take it from the perspective of the person making the complaint, and are that person's facts, if they are 100% true, would it be a violation? And that drives the rest of the conversation from that point on. So they also, SEC has been doing a lot to remind, in their rulings, to remind folks that they've seen an uptick in complaints being filed against board members, and ever since COVID. And what we've been finding is, I've got a vendetta against somebody. I'm trying to use this as a way to get back at somebody. And so they're seeing a lot of those. And so they're starting to make comments in their, especially the ones they dismiss, that This is not the place to air your grievances with each other. And don't try to use this. Now, the law allows, I mean, an actual, if someone filed against me and I said, yeah, I could, in my 20 days, I submit back, the facts are not true, and this is a frivolous, this person's had it in me for years, and I believe this is frivolous. That's a legitimate comeback. They then go back to the complainant and say, it's been claimed that this is frivolous. They ask for more information. They review that, and if they determine that it was frivolous, they dismiss it because it was a frivolous complaint. The statute allows them to sanction and fine the person who filed the complaint $500. And over the last several years, they've been fining more and more people every year. So just be aware of that. There we go. If, in fact, you end up in a case where an ethics complaint has been filed and it goes through the entire process, and if the individual is found to have been, the SEC determines that there was a violation of the act, there are 4 potential penalties that the SEC can recommend. The SEC does all the legwork, right? The School Ethics Commission, they do all the legwork. They do the investigation, they hold the hearings, and then they make a decision, and then they provide the Commissioner of Education with a recommendation. The final decision always rests with the Commissioner of Education, and there's 4 potential penalties. First one is a reprimand, and the language you see on the chart that you have is the new language in chapter 28. They modified the definitions of these so that what you see is now the new language for each of these. But a reprimand is basically a non-public rebuke. What do I mean by that? You'll get a letter from the commissioner saying, Jesse, you did something wrong. Here's what it is. Don't do it again. And that's where the communication ends. The next level is a censor. It's a public formal censor. What that means is if you're given a censor and the commissioner determines the final decision is a censor, the state board passes a formal resolution that Jesse Adams violated the act on such and such a date. Here's all the particulars. And they take a vote, and my name is forever in the records of the state of New Jersey. In parallel, they send that resolution down to the board that I'm sitting on, and the board's required to do the exact same thing. Read the resolution, take a vote, put it into the minutes forever that Jesse Adams, board member on the Cherry Hill Board of Education, violated. So not only do you get memorialized in the state, but in your own town, you get to be added to the record books. But that's what a formal censor is. The next level is a suspension. It's just that the SEC can recommend a suspension for whatever number of days they want to recommend to the commissioner. And then ultimately, the last thing is removal. They can recommend removal immediately from your Board of Education. So those are the 4 penalties. Like I said, the School Ethics Commission makes the recommendation, and then the commissioner makes the final decision. Commissioner can accept that penalty, could make it higher, can reduce it. Commissioner could actually dismiss it. Everything rests on, all the authority rests with the commissioner, right? And like I said, if the decision is appealed, it goes into the appellate court division. All right, so I'm going to briefly walk through the 10 tenets because I think you need to understand a Reader's Digest version on each one of these. But tenet A, pretty simple. You're the elected officials. You have to obey and enforce the laws and regulations of the state, whether you like them or not. I mean, there were a lot of boards that were upset with the governor when he issued executive orders. Those are laws. Those are laws of the state. And maybe people around you didn't like them, but you had no choice. You're required to uphold, you're the elected officials, you're required to uphold the laws and regulations of the state. Tenet B is why you're a board member. I tell boards this every year. This is why you are a board member. talks about your responsibility to the welfare of the children in this district and ensuring that you have a school system that provides the best that you can for them, regardless of their, as it says here, ability, race, creed, sex, or social standing. Your role is not, you're not here for your own child. You're here for all of the children in the district. The decisions you make should be based on what's good for all of the children in your district. And I say, this is what it's all about. You look at the rest of the 10 tenets, you look at the rest of the act, there's nothing in there that says you're here for the adults. Doesn't say you're here for cutting taxes or any of that other stuff. You're not here for the adult stuff. Your job is in law, that tenet is what it's all about. And it's specifically in there. You're here for the children. Your decisions, everything you do should be based on what's best for children. That's tenet B. Tenet C. In this tenet gives you 3 of the 4 functions of a board. This one talks about policy, planning, and appraisal. You're a policy-making body. We tell all the time, we talk, when we talk in foundation of board governance training, which is roles and responsibilities, we talk about, one of the charts we talk about the what and the how. The board is responsible for determining what they want. How it gets done is the superintendent and his team's responsibility. Policy is your way of telling the district what you want. You own policy. Policies belong to you. You're a policy-making body. Your policies tells everyone in the district, the community, what you want and what you expect in this district. Right? Planning, you're responsible for planning. Every year every district does annual district goals. You do those that's part of planning. You might do if you do a strategic plan, that's planning. You're right now in budget planning time. Your BA, your superintendent, they put the budget, but the responsibility of planning a budget is the board's. So planning is your responsibility. And then appraisal. And that's twofold. One is oversight, appraisal of the district. Is the district being well run? How are we doing? You have that 50,000-foot responsibility to oversee the district, but you also have performance appraisal responsibility. Superintendent is responsible for ensuring every employee in this district gets an annual performance appraisal by law. By law, you have a responsibility for one person in this district to ensure that they have a performance, annual performance report each year, and that's superintendent. So that's, like I said, that's a dual-added appraisal function that you have and you're responsible for. Can I get that back one? I think I did it twice. There you go. This one piggybacks off of just what I said. You're not responsible for administering the district, the day-to-day. That's not your swim lane. But together as a board of education, you're responsible for ensuring that the district is being well run. And you do that in your oversight responsibility. Tenet E, authority rests with the Board of Education. You speak with one voice. The Board of Education. Board of Education, right now you have a legally open advertised meeting, right? You tap, you did all the good things you needed to do. You now have authority. You have the power to make decisions. At the end of the night, your board president's going to ask for a motion and a second to adjourn. You'll get that. And all in favor, tap, we're adjourned. When you adjourn this meeting, if there were people sitting out here, you would be no different. You'd have no more authority than any of those people sitting in the audience in this district. Being a board member, you only have authority when you're sitting at a legally advertised. Now, everybody knows you walk around with this big scarlet B on your forehead, right? You go to the ShopRite and someone says, "Oh, you're a board member. I'm having trouble with my son's teacher. I need to tell you about my problem." I know. I used to get cornered all the time. That's not your role. That's administration's role. Somebody corners you and they want to tell you about their issue. Your job is to help them use the chain of command. You have a policy in this district that talks about concerns, complaints, how everybody should handle them. You should know that policy number. You should have that number memorized. You should know that and what's in it, because that's what you should be helping folks who come to you with a problem, help them understand how to get their problem resolved. Because you and then the last tenant amplifies it when we get to it. But you can't start, okay, give me the information and I'll look into it for you and I'll get back to you. That's taken in here to make no personal promises or take any private action that may compromise the board. You don't have authority. Your job is to help them understand how to use the chain of command. That's important. Tenet F, refuse to surrender independent judgment to special interest or partisan political groups, or to use the schools for your own personal gain or the gain of a friend. You know, we've seen an uptick in this since COVID, where board members who are not, this is an apolitical board, has nothing to do with Republicans, Democrats, Green Party, left, right, you're here for the children. That's what it's all about. It's an apolitical board focused on the children. But COVID came along and we saw a lot of boards dealing with the politics that should never be there, shouldn't have been there. And unfortunately, they're still there. But it's important to understand, per the School Ethics Act, you are here to make decisions, and your votes are based on what's best for the children, not for an outside group that you might hang out with, or or a partisan group, or a political group, or a special interest group. Sometimes, I can tell you, sometimes folks get elected to the board through a group that helps them get elected. There's a special interest group, we need somebody on the board, they're not hearing us, we're going to get our person on the board. Great, you got on the board, but there's a law that governs your behavior. And this law and this particular says your votes shouldn't have anything to do with those partisan votes. Even though they got you elected, a lot of times folks get on the board and they realize this is a different animal. I can't do the things and that I thought I was going to be able to do for my part of town, because we tell prospective board members when they come to candidates briefing in the fall, just before the election, we tell them, we go around, sometimes we'll go around the room, why are you going? They'll have their different reasons, and some of them are, we hear the reason, it's like, this could be a rough, if this person gets on, that's going to be an interesting board dynamics. But then we say, okay, well, I'll tell you one I always hear every year. Well, I'm not happy with the superintendent, so I want to make arrangements to remove the superintendent. And I said, well, let me tell you, if you have a great idea, you're a 9-member board, you need 4 friends. Right? Everything's done based on the majority. So if you don't have 4 friends who agree with you, then you're not going to move. So you could be the lone ranger out there continually trying to make a change. And if the rest of the board doesn't agree with you, you're just going to keep talking at the windmill, right? So it's important to understand you're here for the children. And if I tell boards all the time, you stay focused on what's best for children and leave all that other stuff outside, then you'll do good things for kids. And that's what it's all about. Tenet G, that's a dual-hatted one. The first part of it deals with confidentiality. Change. Let me see if I can get that. There it is. Oop, I hit it. I hit it when you hit it, I think, right? First half deals with confidentiality. It's pretty simple. You all are the board members. You get a lot of confidential information in this district. And you talk about it in executive session, certain things that are not allowed to be talked about in public. Confidential information, it's the old Vegas thing, right? What's said in executive stays in executive until that item moves to the public agenda. Once it moves to the public agenda, it's no longer confidential. But if you're talking about items and those items never get to the public agenda, guess what? they stay confidential forever. So it's important to understand, do not breach confidentiality. That's one of the quickest ways to get yourself removed from a Board of Education by the commissioner. So it's important to understand. And the people out there, they know you know. But I used to always get people, oh, what's going on? I understand they're talking about a couple teachers. Yeah, they might be. Well, you're on the board. You're the board president. I say, okay. I mean, that, and even your significant other, you can't talk to them about it. It's confidential, is confidential. Second half of that is two-way communication. You're responsible for ensuring the district has good two-way communication. What does that mean? Right now, one of the ways, outbound, right? Outbound communication coming from the district to the stakeholders. You guys do that every day, whether you know it or not, right? Superintendent sends a letter to all the families about a new program that's coming out, signed by the superintendent. That's Board of Education communication. Fourth grade teachers getting ready to go on a field trip, sends a note home to all the parents, what not to bring, what to bring. Board of Education communication. Every piece of communication that comes out of this district belongs to you because you're the top of the food chain. So as long as you believe and feel that anybody who needs information, whether it's the township or whether it's a parent, they're able to get that information, and you've got good outbound communications. You don't really need to do anything. If you think there's a way to improve it, who do you talk to? Superintendent. Talk to the superintendent, collaborate with the superintendent, come up with a couple ideas, and the board likes those ideas, superintendent will make it happen. That's how you improve the process. But you right now are communicating outbound all the time. What's the inbound? You live in the communities, you're the elected officials. Part of your responsibility is to understand the aspirations of your communities, of your stakeholders. What do they want for their children? When I get to this, I always have to, with the new world of social media, I have to caveat that I'm not talking about the rumor mill, the complaints, all that minutia that's out there. I'm talking about aspirations, parents, folks who say, you know what, I would love to see our math program get stronger for my child and our children. That's an aspiration idea. You hear something like that, you should be bringing it back to the superintendent and to your fellow board members, because you'll hear some aspirational things. Those are nuggets that might be beneficial that you might be able to turn into something wonderful for the children. That's part of your responsibility, keeping your ear out for those aspirational wants of the community. Like I said, it's not the rumor mill, it's not the gripe session. We're talking about things to enhance the education of our system for our students. That's what that's all about. All right. H, vote to appoint the best qualified personnel available after consideration of the recommendation of the superintendent. Personnel, you can't do anything in personnel. You can't hire, fire, transfer. You can't do anything with personnel without the recommendation of the superintendent. Once the superintendent gives you his recommendation, then you have to make an informed vote. Because I always get the question, well, superintendent recommends hiring this teacher. So we have to say yes? And the answer is no. You have to make an informed vote. And your vote is yes, no, abstain, right? Those are your three options. So you should have done your homework so that when you get those recommendations, you're ready, you have an idea of how you want to vote. But you could vote no against, some of the things that the superintendent's recommending. But I always tell boards, be very careful if you're going to do things, if you're going to say no to things like hires and things of that nature, because that sends a message if you're doing that too often, right? So the person who's responsible for the hiring process, the interview process, is the superintendent. You have a policy that talks about you want a legally defendable process for hiring that meets all the laws, and your superintendent is responsible for putting that process in place through regulations, operating procedures, but he owns that process internally. And so you should know what that process is, and by law, he brings you one person for each position. He doesn't give you a couple of choices. He brings, here's my recommendation for this position. and you make a decision based on that. All right. So you need to, because I get this question a lot. Well, why can't we get two? And then we can look at everything and then we'll vote on whichever one we want. Doesn't work that way in education. Superintendent brings you a recommendation. If you turn that recommendation down, it goes back to the drawing board. Repost, re-advertise, re-interviews may bring you the same person because that person may still be the best person for what this district needs. So that's why you need to understand how your process works so that you have confidence that the process is being executed in a fair and well thought out process so that you feel comfortable. All the steps that the superintendent says he takes is being done. And I trust the judgment. I'm going to vote yes, based on the recommendation. So that's what you need to understand. You can't do anything with personnel without the recommendation. Tenet I, the second to the last one, I will support and protect school personnel in the proper performance of their duties. On this one, I tell board members all the time, no board member should ever be heard saying something negative about a staff member in public. By this tenet, you're supposed to support and defend the employees of this district in the performance of their duties. Now, you might have an issue with an individual, a staff member. How do you address that? Chain of command. Chain of command for the Board of Education, one-stop shop, superintendent. You have a concern, bring it to the superintendent, and you've done your duty. Personnel issues is administration, not board duty. So you've given your concern to the superintendent, you're done. You should not expect the superintendent a week from now to give you a report on what he investigated, what he did, if he wrote a PIP, put the person on a PIP, whatever. That's not your role. You're not administration. But you brought the concern, and as the personnel manager of the district, the superintendent does with that information what he believes is appropriate and necessary in his role as the personnel manager. So that's something you should understand. But you should always be protecting and supporting and never talking down or saying anything negative about staff members in this district out in public. Because that will get you in trouble. And then the last tenet is J. All right. And this one goes back to the ShopRite story, right? Where someone corners you in the ShopRite and wants to give you their problem. This one says, I will refer all complaints to the chief administrative officer, the superintendent, and will act on complaints at public meetings only after failure of an administrative solution. Now those words, failure of an administrative solution, sounds ugly. All it means is they followed your policy. They followed the chain of command. They went to the lowest level, tried to get resolution, didn't like the answer. Went to the next in the chain, didn't like the answer. Ultimately, they worked their way up and got to the superintendent. Superintendent reviewed their situation, made a decision, and the person still didn't like the decision. Now, per your policy, they are allowed to request a hearing in front of the board for their issue. Then and only then are you able to weigh in on that complaint or that concern in a formal hearing that's done in an executive with your attorney to hear what the person's issue is. And you will have, prior to that, you will be briefed by your superintendent, everything that's happened, what the decisions were, what the rationale. So you'll have all that information. Then in the end, after the hearing, you then have the ability to deliberate and make a decision. You either uphold what the superintendent did, but you do have the ability at that time to come up with a different solution. And so, but that's the only time. You can't solve somebody's problem in the shopping, in the supermarket because they brought it to you. It's got to go through the administration, always has to get first crack at it. So your job is to help your stakeholders get to the administration, use the chain of command. It's very important. Now, that also applies to public comment. Public comment, folks come to the podium and they throw a bomb on you, right? I have this problem and they want you to solve that problem because that's why I came to the board. And usually they haven't had a conversation with the superintendent. You know, superintendent doesn't even know what it is. And they're trying to get you to solve this problem tonight because I brought it to you. Oh, good. I'm glad. And so, you know, we tell, you know, and board presidents always ask when we get in that situation, you know, what do you recommend New Jersey school boards? We tell you the recommendation is we tell board, you said, thank you very much for your concern, for bringing your concern forward. We've heard you. Could you please make an appointment tomorrow with the superintendent so that he can look into it? Because you can't solve that problem, you know, by law, by that tenant, until the superintendent brings that problem to you based on the chain of command. All right. All right. All right. Those were the code of ethics. Any questions or comments on that material right now? All right, let's keep moving. All right, I'm not going to cover what in your chart. You'll see the next two charts. It has it might be three charts, I think. Has I told you there were 8 commissioner decisions, ethics complaints that were decided. These are one paragraph synopsis of those. You can read those, take a look at them. Like I said, the 4 of the 8 were code of ethics violations. That's these first 4 that you're looking at. A little later on, you'll see 4 more cases. They were conflict of interest cases, which are a different paragraph in the act. But the first one, just real quick, the first one deals with a superintendent search. And there's a confidentiality issue that was breached. So that's what that first one is. The second one deals with a board member and a coach and a superintendent. Board member emailed a coach and a superintendent because he was upset that football players were taking a knee during the national anthem. And that email exchange was not a good one. And so that's what that case is about. And as you can see, it's a commissioner case, so the board member didn't fare well on this one. The next one on the next page, which takes up the whole page, this one deals with a teacher in a district. They were coming out of COVID, returned to school after COVID, and teacher was complaining about health and safety and that they weren't taking it serious and that kind of stuff. The teacher, there were some pictures of the teacher in Cancun, and this board member, sent the board the pictures and said, she's saying we're not taking this serious, and she's out down in Cancun partying, that kind of thing. So that was the start of it. A parent in town found those Facebook photos and also sent it to the full board, saying, look at what this teacher's doing, and then complaining about return to school. The board member replied all to the board, forgetting that the parent, the person who sent the person in the community who sent it was also on there, and that was not good. So that's what that case is all about, and the results of what the SEC found there. And then the last one on the next page, this one was an ugly one. It was actually 2 that were combined into one because it was the same district, same issue. 2 people filed a complaint. Basically, this was a district where a board member on his personal Facebook it was a large Muslim population in the town, and put a bunch of stuff on his Facebook post that was derogatory, ugly, and it got real ugly in that town. The SEC, obviously dealt with it. This one, you'll see that the penalty was a censor. And you'll say, well, and like I said, it was a pretty ugly situation. It got so hot in that town for that board member, they resigned before this got all the way done. And so they couldn't suspend him or remove him because he'd already resigned. But they put a formal censor to make it public into the record what this person did. So that's what that case is all about. All right, so you can take a look at those at your leisure. Those, like I said, those are just summaries. You'll see at the end, the very last page of that PDF, there are links there to the actual cases, and they're multi-page long. If you want to read all the details of what the SEC did, said, and found. Conflict of interest. What is a conflict of interest? Basically, in the School Ethics Act, I think it's a paragraph B in there. It talks about things that could cause you a conflict of interest as a board member, and things that are listed are the kind of things that you got to be aware of. You know, things like business interests, financial involvement, and gifts, favors, financial gain. These are things you need to be aware of. And what do I mean by be aware of it? As you're doing your work, looking at your agenda, voting on things, you need to, in the back of your mind, you should always ask for every item you're going to take a vote on, one of those simple questions in the back of your mind. Do I have a conflict? If I take a vote on this item, is there a conflict of interest for me? If you're not sure, ask your board attorney. If your board attorney's not around and you're not sure, we always say, when in doubt, step out. Don't take the vote. If you're not sure you have a conflict, and there's nothing wrong with saying, I'm going to abstain because I'm not sure if I have a conflict here. There's nothing wrong with that. But you don't want to be taking a vote on something that you have a conflict on. You're not sure. You find out you've made a vote on something that you should not have. Now you've opened yourself up. Now that 180-day window is open for somebody to file an ethics complaint, because that's a statute of limitations. From the time the act was known, 180 days, if somebody wants to file a complaint against you, right? All right, relationships. In addition to conflicts of interest, relationships could get you in trouble. And what do I mean by that? Family members and others, as defined by the law. What you see on this chart, you see the smaller blue boxes at the top. Those were the original definitions. Chapter 28 regulations that just went into effect expanded those definitions. You can see those on the bigger boxes. For immediate family member, it was expanded to include spouse, civil union partner, domestic partner, or dependent child residing in the same household. Dependent child was modified to read any child claimed as a dependent on federal or state tax returns. It used to say and, so you had to have them both. They realized that was dumb. It's either or. Or if you claim them on one and you don't claim them on the other, they're still a dependent. So that's that change. And then relative. Used to be the old definition in the original law: spouse, natural or adopted child, parent, or sibling. Since 2015, the School Ethics Commission has adopted the nepotism law definition for relative. And as you can see, it's pretty, a lot more expansive of what potential relatives could possibly cause you a conflict. And it's not just your relatives, but it's your significant other by blood, marriage, or adoption. So it's really a large aperture of the number of people that potentially could cause you a conflict. So what that means is you need to know, my brother has a landscaping company and his bid is in on our landscaping. We're going out to bid on landscaping and he submits a bid. I got a conflict of interest because he's my brother. So I need to recuse myself from that discussion and vote. So that's what that means. It also may mean you have issues as it relates to negotiations, and also if you have relatives who work in the district, and they were here before you got on the board, they can continue to work in the district. The law allows that. But no new relatives could be hired in. That's the nepotism law. But if you have relatives who work in the district, you have a conflict as it relates to personnel. You have a conflict with anything personnel related to your relative and anybody in the chain of command to that relative. You can't be involved in any personnel activities relating to the chain of command. Who's at the top of the chain of command? Superintendent. So if you have a relative in the district, you cannot be involved in anything relating to the personnel side of the equation of the superintendent. That means you're not allowed to be a part of the evaluation. You're not allowed to be a part of contract discussions. You're not allowed to be a part of salary discussions. Anything personnel related, you're out of if you have a relative in the district. And one of the most important things you do is hire and maintain the superintendent. So yeah, you would be out of one of your biggest responsibilities as a board member. But that's one of those things if you do have a relative in the district. Yes, sir.
So quick question I had. I noticed aunt, uncle, niece, nephew on there. Cousin was conspicuously missing. Can you
Yeah.
clarify?
It's originally a few years back, it was on there, and then the lawyers got together and they realized that cousin for some reason was taken off the list of relatives because there was like first cousin, second cousin, and it was determined, yes, cousin is not on the definition, but they also have this in the definition of in the nepotism, there's all those things and other. And that other's a catch-all, right? Kind of, and depending on the situation, cousin cousin may be a Spanish teacher and wants to apply for a job in the district. Your attorney may say that's a problem. And so that it wouldn't be one of the named relatives, but it would fall into that other category. So that's
Okay, thank you.
Yep.
Appreciate it.
right. Like I said, if you have relatives in the district, but also if you have relatives in education in other districts. So you don't have any relatives in this district, but you have a sister who's a teacher in a neighboring district. You may have an issue when it comes to collective bargaining in your own district with the association. And it just depends on the situation and what role your relative plays in the association at the district that they're in. The A2417, you see under collective bargaining, it says A2417. That's a public advisory opinion. A24 is a numbering system. 17 is the last two digits of the year. So that's a 2017 public advisory opinion. In that public advisory opinion, they took a whole bunch of different advisories about collective bargaining and who could do what, and they put it into this one. This was released in September of 17. And that you see the smaller table. The table in the advisory opinion is longer. And on the left, it has all these different scenarios. And depending on which scenario you fit, if you have relatives, then you just go across and the columns will tell you whether you can participate in negotiations in your district and whether you can vote on the contract. So that's the purpose of the table. So if you have relatives in education in the state of New Jersey, not Pennsylvania or anything, but in the state of New Jersey, then you need to understand what their role is. Are they a union president in that district, or they just a dues paying member? That there is a difference as it relates to conflicts that you might have as it relates to negotiating the contract in your district that you're a board member on. Couple of other quick things. Understand that you may have a relative who may not be in the association. Maybe a confidential secretaries are usually not in any association, right? So you have a confidential secretary, relatives who are confidential secretary, but you may have a issue with the collective bargaining agreement because most districts, I haven't found one yet, but benefits, medical, health, dental, everybody usually has the same plans that the large association has, right? And so it's so even though your relative is not in the union, there's a benefit that they get from that contract. It's called linkage. So you would have a problem being able to participate in the negotiations for the contract. Those are those kind of things that you want to talk to your board attorney to get advice on whether you're in or out, depending on what's happening as it relates to your relatives and negotiations. The next four cases, I said were conflict of interest cases, and you can look at those when you get a chance. The first one, two board members, settlement agreement that they were involved in and they were going to get a benefit from. They voted on it. They should have voted on it. That's bottom line on that. Second one is an open public records case where a board member who was not involved, the case wasn't about them, but they were asked to provide information. Therefore, they now had a conflict because they were a part of it. Should not have been in the executive session talking about that kind of stuff. That's what the second one is. The third one is can't tell. Two. And there it goes. Yep. The third one is a per diem situation where board member whose daughter was a per diem sub in the district. Merit goals are being voted on for the superintendent, and board member voted and should not have voted on the merit because it was a personnel item relating to the superintendent. And then the last one is another open public records case, but it has to do with election time, and there were some situations in the executive session. So that's what that one's all about with the conflict of interest. So you can take a look at those at your leisure. Advisory opinions. These are 4 of the 8 advisory opinions. You can take a look at those, and each one of them and the advisory opinion numbers are there, and it talks about bus driver who's a board member in a district, but also a bus driver in another district. Question about whether he can be involved in the negotiations in their district, those kind of things. The second one talks about superintendent merit goals again. The third one is an ex-spouse, board member's ex-spouse works in the district. There's a spousal and agreement. So can this person be involved in negotiations? There's the potential that, hey, if you get a good contract, a raise, it might help me out with my my alimony, So those kind of that's the advisory opinion talks about that. And then another one talks about an aunt-in-law and a distant cousin in that last advisory. And it says basically not per se, but you got to look at each situation because it might fall into that other category where you do have a conflict. And then the last 4 of the 8 are all relating to folks who have some affiliation in their private jobs with school districts, providing services, et cetera. And does that cause them a conflict on the board they're sitting on? And that all 4 of those are addressed there. So mandatory training, I think the veterans know this and the new folks are learning it, that you have mandatory training, new members, first 3 years, governance 1, governance 2, governance 3. Governance 1, new board member orientation, governance 2, finance, governance 3, student achievement. Chapter 28, change, that went into effect February 1, does not affect the new board members sworn in January, but April, those who still have April and everybody going forward, mandatory training. Your mandatory training requirement, you have to get it done in 1 year, right? 365 days to get it done. The law has changed for Gov 1. First year members, you have 90 days from the date you're sworn in to complete your governance 1 mandatory training. So next year, if a new member comes on board, they will have 90 days to get their training done. And so we are in the process of revising our training schedule and everything to try and front load in that 90 days opportunities for folks who, you have multiple ways to take it, either in person, the weekend program in person, 1 day person in program, live virtual, or the online a self-paced program. So, timeline wise with this change, we're now not revamping, but reconfiguring when we're going to do these because we have to be able to meet that 90 days for the members to make sure it's available. Because there were board members taking governance 1 in October. And so they basically said, you're a new board member. This is the stuff you need to get out of the starting blocks. That's why they changed the timing to 90 days. Governance 4, every reelected term, the first year of your reelected term, you have mandatory training. That's governance 4, which is the legal and legislative update, right? mentioned, we talked about disclosure statements. Those are, you understand those. April 30th every year, except those are newly appointed 30 days, your first time 30 days after getting sworn in, thereafter April 30th. The one thing that's been happening more and more each year, folks fail to complete their mandatory training by the end of the year, or they fail to complete their disclosure statement on time. Folks have been getting penalized for that. What Chapter 28 did, what they did in Chapter 28, they formalized what they've been doing to board members for failing to do those. They formalized it in Chapter 28. So basically what's going to happen if you fail to complete either your disclosure statement or your mandatory training, and the SEC gets notified, which we notify them, or we notify them for the training and the state notifies them for the disclosure statement. Between the time of what happens is they will issue you what's called a show cause letter. You'll get a letter saying, basically tell us why. If it's a new board member, in 90 days you didn't get it. Why in 365 days you didn't get your training done, or why by April 30th you didn't get your disclosure. So that's a show cause. So you got to explain and convince them why you whatever the reasons were that you didn't get it done. From the time the show cause letter is issued, obviously if the show cause you give them good reasons, then you're off the hook. But if from the time the show cause letter is issued and you don't have a good reason, and the time that the SEC makes a decision to send to the commissioner, if between that time period you get religion and say, I'm going to go get it done, and you get it done and you show them proof that you got it done, and you got it done before the SEC made their decision and sent it to the commissioner, you will get a censor. You're going to get something. The minimum you'll get is a censor. So you didn't get it done by the time they sent their recommendation to the commissioner. From the time they send that to the commissioner and the time the commissioner makes her final decision, if you get religion then and get it done and show proof, then you'll only get suspended. If you fail to get it done by the time the commissioner is ready to make her decision, the decision is you're being removed from your board. So that's the timeline, the penalty line that's going to happen for those now. And they've been doing that. They just formalized it in Chapter 28. Yes, sir. I'm sorry.
How crazy do they get about doing it in the exact right year? So I started January of 2022. I did my governance 1 training within the first couple of months there, and then when I went to the workshop in Atlantic City, I took board governance 2. Does that count for my second year? Am I good?
The School Ethics Commission has said, if you complete your current year, whatever your requirement is, and you do your next year's requirement anytime after October 1st, you'll get credit for it. So workshops, well, that's why we do that at the end of the month. On workshop, we provide them. So if you've got 1 done and you want to do 2 and you do it at workshop, you'll get credit and you'll kill next year's requirement. And you can take, and then as you get to October of the following year, you can go ahead and take 3. You can stay ahead. But October is that magic date. If you do it before October, then you're wasting your time because you're going to have to take it again. All right. Volunteering in schools. That's for those veterans who've been around, you know that back in 2015, the rules started changing on board members being able to volunteer within the school district. And on the chart, the 4 blue boxes, basically those are the criteria that you should think about because you're the top of the food chain. You're the school board, and there are certain restrictions that you have when you participate in volunteer activities in the school, that if certain conditions exist, like staff giving you direction or you directing children, those are things board members are not allowed to do. So in a volunteer organization, if you're volunteering and taking direction from staff, or you're directing children, That's out of your swim lane. The SEC said that's not allowed. So handling school monies, you're not allowed to do that. And so if you're in an activity where you're handling school monies, so what you should do is if you have an activity you want to do, you should talk to your attorney. Say, here's the activity, here's the things I do, here's what kind of guidelines there are, and the attorney will tell you whether you can or cannot participate in that volunteer activity. All right, interviews. We talked about interviews earlier. Bottom line is SEC, the board members should not be involved in any interviews. The process belongs to the superintendent. Administrative role, the hiring, interviewing, hiring, recommending a hire is the superintendent's responsibility. But the SEC has said there's one condition that board members may participate in an interview process. And that's when you're hiring what they call the senior positions, like a business administrator, assistant superintendent, those higher level positions. Board members may participate if invited by the superintendent. Superintendent owns the process. Superintendent, let's say the superintendent wants to hire an assistant superintendent and they're going to do a panel. And first round is going to be with a panel, and he'd like to have a board member on. Maximum of 2, the SEC says, can participate, and you have to follow the rules, whatever the rules are for that superintendent is set for how the interview is supposed to take place. You follow, you can't go rogue and do your own thing because you're a board member. But if the superintendent doesn't want anybody on those, you can't insist on being on it. So it's the superintendent's call. That's the only condition where board members may participate in an interview process. Exit interviews, just to mention, you never are involved in any exit interviews, and you never get any information from the exit interview. That's all purview of the superintendent. Social media, getting close to wrapping up here. Social media has been hot. Okay, you need to understand that. A couple of things that the SEC has pointed out, and they've said it several times. And in fact, I got an email today from our legal folks on a dismissal of a case. There's a social media case, and they reiterate the things that we have on this chart about school board members. And the bottom line is they basically say you don't lose your First Amendment rights when you become a board member. But because you are an elected official, because you are a board member, you have additional restrictions you need to think about if you're going to play around in the social media world. And so one of the things they talk about, and it's highlighted in here and it's on there, is that I call it the preamble. It's called a disclaimer, and it's a disclaimer that basically says, well, first let me back up. The SEC looks at cases where social media ethics complaints been filed, and they look at what was said and what was by the board member in that post, and they look at it in from the perspective of whether a reasonable member of the public could perceive that the school official is speaking in his or her official capacity or pursuant to his or her official duties. If they believe that that post could be by the common person out there, looking at that, seeing your post, knowing you're a board member and read that statement, if the SEC believes they could perceive that that's the Board of Education speaking, then that's a problem. All right. So that's kind of the big picture of what they look at. The other piece is that they look at, if you're going to play around, and this is the old days. I mean, a long time when I was a board member, there was a case, and we didn't have all this technology, social media back then, and it was letters to the editor. There was an advisory opinion that came out that said, a board member wanted to know, can I write a letter to the editor? And the SEC said, you don't lose your First Amendment rights. You can write a letter to the editor, but you have additional restrictions. And the first one thing they said, you need to put a disclaimer. And the disclaimer is basically something that reads that doesn't have to be exact, but it says something to the following statements are made in my capacity as a private citizen, and not in my capacity as a board member. These statements are also not representative of the board or its individual members and solely represent my own personal opinions. That, I call that the preamble. I used to tell folks before the social media days, you got to make sure you have your preamble on your letter if you're going to write a letter to the editor. And then what the SEC has said, if you do that opening statement, that preamble, then you're allowed to say whatever you need to say, as long as it's factual and doesn't breach confidentiality. All right. So that was that old letter to the editor, the rule. Fast forward, it still applies in the social media arena. And that's what basically you're going to be out there posting. You need to make it clear. You need to have that disclaimer. You need to not talk about board business. It's important. They said having the disclaimer and then going on talking about things that can be construed as board business defeats the purpose of the disclaimer. And there are cases where that's happened. Person put the disclaimer, dotted the I's, crossed the T's, and when they did the investigation and the hearing, they went through all the posts. Was talking about everything they talked about was board business. Personnel hirings, the things board members do and would know. Person got a censor because content matters, right? You just can't throw the disclaimer out there and think you're going to be able to get away with it. So it's important that you understand that. So it's important from a social media. And I had a person ask me, so even if I just want to do a one sentence blurb on a post, I got to put that. I said, that's what the SEC is recommending. You put that one sentence blurb in there, and if it can be construed as board business, and you didn't put the disclaimer, or even if you put the disclaimer on it, and somebody files an ethics complaint, you're going to have to answer to the SEC. Ethics compliance. There isn't a ethics compliance police force running around. The School Ethics Act is designed to be self-compliance. You know the rules. Here they are in black and white. You should be talking to your attorney. You are responsible for not violating these things. So it's important to understand that. So there's nobody going to be running around. So you might get away with doing a lot of posts that might get you in trouble. And as long as nobody files an ethics complaint, I guess you can get away with it. But realize statute of limitations, 180 days from an occurrence of something that somebody can file an ethics complaint against you. So it's important to understand you have a responsibility. The SEC looks for board members to put all that extra stuff in there. And they're not saying you can't do social media. They just say you got to make sure you're doing it appropriately and with the right disclaimers and doing it as a private citizen. And content matters. So make sure your content is speaking as a private citizen. All right. Yes, I'm sorry. Yep.
Does that count if you are not responding, but commenting on something that's written specifically about you? Like if it's a board issue, but then they like to pull out names and say, Corinne Elmore Stratton is this, and this. I can't jump in there and be like, Corinne Elmore Stratton is a public person, blah, blah, blah. I don't know.
You have to decide whether you're going to jump into that fray or not. And you have to be careful because, obviously your preamble for public comment says we don't, you point out, you could be liable, all that good stuff. Same rules apply, but you have to be careful. You go in there to defend yourself, so to speak. And it's because they're commenting about your board business, you could potentially have somebody file against you. And now you're sitting in a hearing up in Trenton trying to explain why what you did was okay. So we tell folks, there's no magic yes or no. There's no magic yes or no. Everything that the SEC looks at, it's case specific. They're going to look at your case, the facts surrounding your case, and determine whether that was appropriate or not. So they give, like these public advisories, they give you a scenario and a case. There were specific facts around that advisory that they made that decision. You can say, oh, I can do that. And you go off and do that same thing, but there you do something just a little bit different in your facts may have one additional different fact that sets it apart from you shouldn't do this. You think I can, okay, if I don't do that, I can do this. And you do this, and it's that one little twist. You say, well, wait a minute, how's this different than the other one? Your one specific fact may make it different. Each one of these is case specific. And that's why, it's general from the perspective of the landmine that you want to avoid, but it could morph based on the facts. Every time a person does something, the facts are going to be a little bit different and may have a different impact as it relates to the law and what the SEC looks at.
Okay, and then one more question.
Mhm.
And I shouldn't be asking this because it's my fourth time here, but what about when if a community member comes to your door or something like that, and at that point, am I just a private citizen?
You are a private citizen when you walk away from the board table. Now, what I would tell you is that if you're a board member and somebody's coming to your home, you got a different issue. It's not just board business at that point. And, I would be talking with police officers and that kind of stuff because you've got a potential different situation that could arise if they're coming to your home.
Okay. And in regards to ethics with endorsements, can you explain what we are allowed to endorse or not? And I'm talking endorsements in terms of like other political office. Like I know we can't endorse other people when they're running.
You can endorse whoever you want, whether it's, the mayor, the election, but you can also endorse board candidates. You just don't do it as a board member. It's that I'm speaking as a private citizen and I'm endorsing so-and-so. If you're saying as a board member on the Cherry Hill East, I think so-and-so would be you're basically what you're trying to do is influence folks because you're a board member. You should take my word that the candidate I'm endorsing is the right person to vote for, using your position to influence something. So, yeah, but if you wanted to help someone on their campaign, work on their signs, go out, pass leaflets, you're perfectly allowed to do that as long as you're not doing it under the guise of I'm a board member. Yeah, you can do yard signs. You put them in your yard, but you want to make sure you're not doing it under the guise of I'm a board member. Now, I had somebody say, well, if I'm a board member and I put a sign in my yard for someone a friend of mine who's running, they know I'm a board member. Yeah, they know you're a board member, but your sign doesn't say, as a Cherry Hill board member, I endorse so-and-so. So-and-so would make a great candidate. You're not flouting the fact that you're a board member. So you got to be, you're acting as long as you do those things as a private citizen, no one can tell you who to endorse, who to vote for, et cetera, et cetera.
Mr. Adams, I have a kind of follow-up question to the
Sure.
first question. And I'm not suggesting that this is a good remedy, but it was curious to me because I recall hearing about a board member who was very incensed about being personally attacked by name in public, whether it was on print in social media or it was in person. And the board member said, I'm going to take legal action against that community member for attacking my name. And I guess it would be libel or, and so board members who are private citizens have a right to take legal action against others who slander or libel, which would
Yes.
obviously would have to be something, they're saying something false,
Right.
accusing, saying something false or accusing
Any
them
libel
false
case, you've got to prove that what they're saying is
false, right?
But yeah, you don't lose your legal rights. You don't lose your First Amendment right just because you're a board member. You have, if somebody says something that's inappropriate about you and you take issue with it and you turn your lawyer loose, that's perfectly within your rights. Yeah. So sometimes people say, well, I'm a board member now, I can't do all the, you don't lose those rights. None of us lose those rights. Even the elected officials don't lose that right. And you're elected officials.
It's just tricky because like the last couple of years or whatever, there's been like if you Google any of us right now, we're on certain websites as the board member to watch, the board member to hate, that kind of, this one is a white supremacist. Like it's literally, that's kind of stuff is out there. And all I've been told is can't do anything about it. Just gotta, it's
Yeah, I
on,
mean,
it's nothing you can do about it.
but I mean, look at it in terms of not making it political, but look at the political arena. There's folks out here who are sitting in political office. They're getting hate mail. They're getting stuff said about them on Facebook and and they can't chase everybody down. And so, yeah, I hate to say it, it's part of the territory when you step into the arena. That if folks who want to take a shot at you, you're going to take a shot.
Yeah.
It's just that there is a limit, and like I said, somebody coming to my front porch, that's not good, because I'm not gonna. I know personally, I'm not going to deal with that very well. So I'm going to keep the door closed and let the police come take care of it. You know?
And I think that's the piece, is that, everyone has their own limit, and, I think the limits keep getting pushed for board members in terms of what comes at us and what we're dealing with. And that's not a brand new thing there that's happened to board members in years past as well. But I just think
it's gotten more heightened.
it is
since
more
COVID.
heightened. Yeah.
And-
And I mean, I think when you're constantly hearing your name and, it's seeing your name in print, saying things that you've done, which are just not true,
Yep.
starts to get to a point where, as a private citizen, you feel like you can't do anything directly to defend yourself except perhaps protect yourself. So
And I will say, having been a board member for 22 years, like I said, you don't get paid for this. You're a volunteer.
Wait, what? What? Say that again, please.
You don't get paid.
Is
for
that
this.
why I have not received the direct deposit for 2 years and 3 months?
And, you
We
know,
thought
you're-
maybe there was some type of no.
You're volunteers. You're volunteer elected officials. You volunteered to ask people to put you in this seat, and people don't realize it. And you know what? It's a lot easier to be on the outside throwing stones than be inside trying to make a difference. And so I just tell board members, you got to realize what you're here for. Head down, stay focused on the kids, leave the adult stuff out there. Let the adults deal with the adult stuff. And that's tough, but that's why I always say, and it's like a broken record. It's not about the adults, it's about the children.
Yeah,
Sure.
My last question, or maybe not. What about if, and again, these are all hypothetical situations, but what if someone is during public comment and like openly slandering a board member,
Well-
and that it's gonna live now on the internet forever, and it's like something completely, inflammatory and wrong.
Yeah, well, you need to ensure you need to understand what your public comment process is, because you own it. You own the process. Open Public Meetings Act requires every government entity to offer the public at least one period in the meeting for public comment. And that's all it is. It's all it's supposed to be, is a comment period. It's not a dialogue period. And so that's why we always tell, thank you for your comment. Appreciate it. If it's a concern or something, please make an appointment. Next. It's not it's not supposed to be a dialogue. We tell board to be careful. When you get into a dialogue, you can lose control of your meeting. And there are boards who lose control of the meeting and they don't get into a dialogue. It's just people don't want to sit down. But it's important to understand that, you manage the meeting, and we always say, make sure that folks out here know the rules. And, some boards have a very, yours was relatively short. You hit the key points of what public comment was all about. There are some who read a novel basically, but they're basically telling you, we don't accept this. We don't, slander. You don't do this. We don't talk about students. And they have a whole list of things and what we don't allow. And we spell that out, and it's in your bylaws. It's in your your meeting public comment bylaws. Here's the rules. Here's the things that we don't allow. You set the rules. And so if somebody is out of line and strays from that, that's where the board president can tap, We don't allow that. That's part of our bylaws and they should stop. They don't want to stop, then you got a problem and you may, like in one district had started to have the police there because they couldn't get people to relinquish the mic and they were breaking the rules. But yeah, and so there's no magic formula. You set the rules. In your hypothetical, you said where somebody slanders a board member and the board member wants to respond, that's you guys have to decide that as part of your rules and your protocol. But don't do that on the fly when somebody has done it. You should have that conversation as part of your policy discussion on what are our rules. First reading, second reading, here's our rules. And we always said when we did a program on, communicating during adversity, and basically in that program, we say, don't plan to set the rules when you're in the firefight. Plan ahead. What if? Do the what ifs. All right. What if in a public comment, we have someone who does X, Y, and Z? What would we do? Let's have that conversation. Talk about the rules and your process and your policy in advance. When the times are calm and good, that's when you should put your plan together and your structure together so that when and if, no, not if, when, everybody always has at least one instant that brings a packed house to you. So when that comes, you know how to deal with it because you've planned for it. Versus you're in the firefight, somebody does something and say, whoa, that never happened before. We can't accept that. Now everybody wants to jump out of their chairs and you weren't ready for it. Do your planning in advance before the adversity hits.
Yeah, we just went through that actually as a board. We just had a discussion about our public comment and how, changing the language because it was the previous public comment language was devised by the previous board. So we just updated all that. So it's helpful. And I think it's, it was a great discussion and a lot of, input from the board.
The
So that was
big
good.
thing that I tell boards, and a lot of boards are doing this now, is that you have to educate your public. They don't understand that public comment. This is not the public's meeting. It's the board's meeting held in public. By law, you're required to hold it in public because the public is allowed to see you make the sausage. They don't get to cook it. They don't get to fry it up, but they get to watch you make it. So this is your meeting to do your business. It's not their meeting. They can come and observe. And the Open Public Meeting Act gives them the opportunity to observe and to give a comment at least one time in a meeting. But all the other rules belong to you. You set how many minutes you're going to give people to speak. How long is your public comment period in total going to be? What happens if you get to the end of that period? Is there a process to extend the time? Motion, set, all those rules, you should have all that spelled out so that when you get a situation and you've got, a dozen people wanting to say something about a hot item and, and everybody gets their time and then still the line's still there, how do you don't want to cut it off because that might not be a good thing to just cut it off. How do you extend? What's your process? Make sure you have a process and consistency. And I will tell you short story about a district. It actually happened. They always had small district. They always had great relationship with the community. Every public comment was a question back and forth, talking, Something happened with one of the administrators and the superintendent was taking an action and the word got out, packed house. Person got up for public comment. And they had a bylaw that said 3 minutes per person, all that good stuff. They never enforced it. Person got talk as long as you want. But because we were all buds. Person got up, started making their point, and they knew it was a hot night. They knew it was coming. So they had, board president had to watch. Said, your 3 minutes are up. The place went crazy. What do you mean 3 minutes are up? Said, well, our policy is 3 minutes. They said, where'd you pull that one out of, right? You know, we've never done 3 minutes. Well, tonight we're going to follow the policy. Mm-mm. They lost control of the meeting. They ended up having to cancel and reschedule. Lost control of the rescheduled meeting. They had to call the police in, and it took a year for them to get their board meetings under control with police there every night because they were inconsistent. Number one, they had a policy, they never enforced it. They used it as a good time to dialogue with the community. And when it got hot, the community was like, where are these rules coming from? So set your rules, be consistent, and educate your public about the rules. There are boards who put public comment rules on their website so that people can see them and read them. There are several districts I have a brochure, public comment brochure. And they have it at the door where the agendas are, where the printed agendas are. People take the agenda and there's usually that blurb is on there about public comment. Most people don't read the blurb. They're looking at the agenda items. But if there's a pamphlet sitting there next to them, they say, oh, there's another document, they pick it up. They're going to at least look at this pamphlet to see what it's all about. And if your rules are there, they might even read them. So the more you do to educate your public about the rules, regardless of how hot the topic is, if they know the rules, they're going to abide by the rules. They'll get their say, but they'll follow your rules. And that's what you want. You know, so.
Thank you so much. I mean, I think, right, I know we're a little over on time and I want to make sure we get other questions. And so.
Problem. And I think.
Is that okay? Do you have a little more time for us if we all want to?
Yeah, you can ask. I'm here for all the questions. I'll wrap
Thank you.
up with the fact that this is the time of year that you should do we recommend 2 things. Take an inventory of your relatives in the district and in the district and in education. Those that are in education, so you know who they are. And then also take an inventory of your volunteer activities, things you like to do normally and volunteer for, and what those activities are. Why do you take those inventories? We recommend you give those 2 lists to your board attorney. Okay. Here's my relatives. Here's the districts they work in. They're in education. This one's a union president. This one's just a ranking file member. Here's the several items I like to volunteer for. And here's what happens, my role in this. The attorney will look at those lists and come back to you and say, okay, you're conflicted in negotiations because of this, this, and this. These 6 volunteer activities, you can do 5 of the 6. This is the one you should no longer be doing. At least then you know what's going on and what you can and cannot do. So the other thing is school board notes. You get a lot of stuff from school boards, emails galore. And I know, I get told all the time, I can't read all this stuff. I dump it. I said, I know, I was a board member 22 years. I dumped a lot of stuff too. I didn't have time to read it. One thing I recommend you, if nothing else, you open it when it comes in your mailbox, is school board notes. And you look at the table of contents and you look for an advisory opinion, ethics advisory opinion update. Our attorneys attend every SCC meeting and to see what's going on, what they're doing, but also to hear if there are any new public advisories being issued. They issue a public advisory, our attorneys come back, they write an article about it, and they put it in school board notes. That's how we ensure that the membership is aware that they just put a new landmine in the mine. That you know what it is, so you don't step on it. So if you go through the table of contents, you don't see an advisory opinion stuff, then if you want to dump it, you can dump it. I'd recommend you read it because there's still other good information. But school board notes is our way of making sure you know if there's new advisory or ethic decisions that are coming out. So with that, I'll stop and answer any more questions you might have.
Thank you. And just Mr. Adams, in our effort to always be communicative and transparent with the community, since we're recording this meeting, if you wouldn't mind when you answer, just to speak closer to the microphone. So everyone, including anyone who wants to look at the meeting, can hear. So thank you. All right. Questions from board members, comments? Okay. Mr. Mayor.
Yeah, not a question. Mostly because I've been through this before and attended some of your other seminars. So thank you. First, I know it's hard for you to get to all the places you need to go and give this information. And all of it is topical, but we live in unfortunate times when school boards and meetings have become too much of an area of conflict, where other issues that community has reason to be concerned about, sometimes it's played out here. And that does present challenges ethically. So having the opportunity to hear from you about some strategies to address that is helpful. I don't take any of this for granted, and always look forward to hearing your opinions and advice, and generally I'll look a little further into some of this and check out the cases and make sure we're on the same page, and I appreciate your responsiveness also when, we do have issues or questions that come to you. So thank you for the time, and I look forward to hearing from you again.
Appreciate it, and good luck. Good luck. Hope, I always tell boards, have a great board year. Let's have a great
That's
board year.
right.
Let's get to Christmas and be real good about it.
People, I just have a couple of
Sure.
quick
Mhm.
things. Could you just briefly, because this has come up several times, could you just talk about the use of abstention? When board members are abstaining on a vote, and what are the reasons? Like sometimes it's confusing about, if I don't agree, do I abstain, or do I, or if I'm abstaining from, one item, how to do that in the agenda?
When we do our parliamentary procedure training, we talk about it. One of the things we talk about is abstentions, and an abstention is not your way to get out of a vote. It's not to be, this is a tough vote, and it could, 50% of the room is on one side, 50% on the other, and I don't want to get in this firefight, so I'm going to abstain. Yeah, like I said, you get paid the big bucks to make the decision. So, but abstaining should not be used as a way to avoid voting. It should be used from the perspective of, I just don't have enough information to make a good decision. For example, the item may have been discussed at the previous meeting and there was a good, robust discussion, but I was absent and I wasn't able to get brought up to speed. And I come to the meeting and we're voting on it tonight. I might not feel comfortable because I just don't have all the information. That's a perfectly legitimate reason to abstain. I have a conflict of interest. I recuse myself. I don't get involved in the discussion, and I abstain. You don't have to give a reason why you're abstaining, because some people say, well, if I have a conflict of interest, should I say I have a conflict of interest? No, you're not required to. A lot of people do. They say, because they want the public to know, I have a conflict of interest on this, so I'm going to recuse myself and abstain from the vote. That way, so there's no magic, but it should not be used to avoid a vote. And it's basically, and when you do say abstain, it's a non-vote. It doesn't play into the decision.
Thank you. And just briefly, we're at budget time, as you know, and it's challenging, right? It's a difficult time. You have constantly competing, needs, so to speak. We always keep the students' needs, first and foremost. But, I wonder if you could speak a little bit to that. I like to refer back to for myself, I reread this year again, the fundamentals of board membership, and the piece about budget. It was balance the educational needs of the students with taxpayers' ability to pay. And I think, you touched on it earlier, but I wonder, it might be just helpful to hear a little bit more about how you manage that. It's tough.
I mean, especially with the way funding is going right now, and I'm not sure which side of that equation you guys are on. So it's really important to understand it. Your community, there's an unlimited pot of gold out there that they can give you, and that's why the law was put into place that max tax levy 2%. That's the max you can take it up to. And the idea is that you have the hard job of doing the best for the children within the resources that you're getting. And as a November election board, 2%, voters don't get a chance to vote on it. If you need more than that, now there are some other things that are in the funding formula and in the equation that you can get adders based on insurance, wrong with certain things. But But the standard is 2%. If you need something above and beyond that, that's not in your T&E budget, thorough and efficient education budget, then you go out for a second question and then the voters can vote on that item. But you have a tough job of balancing. You only have so many dollars. And then you know how much you're getting and the max you can get, and you've got to do the best you can with the programs that you have. And you all end up making tough decisions on what to retain, what to cut back on, because it's all got to fit within that budget, that financial constraint that you have on that 2% cap. And like I said, you're not getting a ton of extra state aid coming from the state. So, and every board, every district has its own challenges. And it's just a matter of trying to figure out what are your priorities for the children, and then trying to ensure that you make sure that the funding is there to do those. And if you prioritize it, the most important things that give you the biggest bang for the buck for the children, that's what you're trying to do with your budget. And unfortunately, your budget's also, there's not a lot of discretionary funding that you can play with. I mean, what, 80% typically is salary and benefits, just to have your teaching staff do the programs.
In Cherry Hill, it's only 75%. So
Okay.
we're pretty fiscally responsible here.
There you go. So, but I mean, if it's a large chunk of the budget, then you've got other things that are fixed that when they go up, you got to pay them. And so, yeah, it makes it tough. It makes it tough on the program, but the program side of the equation, when you want to try and add new things and enhance your programs, that's the balancing act that you guys have. And it's a tough one. It's gotten tougher over the last 10 years.
That was helpful. Thank you. All right. I got a chance to ask mine. Any last second? We're way over. Thank you all. Jesse, Mr. Adams. Thank you so much for, giving us your time,
Thank you for the
making it down to
opportunity.
Cherry Hill. Thank you to all the board members, to all the staff, all the administration, and I really appreciate it. And now we'll go back to closing the meeting, and I would ask for a motion to adjourn. And I have Dr. Rude, and can I have a second, please? Okay, Mrs. Tong, all in favor? Say aye. Thank you. Okay, motion passes. Meeting is adjourned.